Mhm. Yeah. Now, I did want to mention a couple other amendments.
Yes.
Mhm. You know, there's what's called deprived of life, liberty, or property
Yeah.
without due process of law.
Oh.
Mhm. Now, if I was to define the due processes of law in the state of Washington,
Hmm.
I would say that much of the definition of that is the Supreme Court rules
Yes.
that every prosecuting attorney should have to have enforced
Yes.
when representing the people of the state of Washington. Now, for the arrogant piece of crap right now, it's a Fifth Amendment violation,
Yes, it is.
a 14th Amendment violation,
Yeah.
and in many instances, it's a 13th Amendment violation to have somebody arrested for the false accusation of violating the restraint provisions
Yes.
of a protection order that was issued during a civil matter
Yes.
where the individual didn't actually serve the person,
Hmm.
so the judge didn't inform the indigent individual of their right to have legal counsel. Now, these due processes in the Fifth
Yes.
and the 14th Amendment, and then those rights of the Ninth and 10th,
Yes.
and then there's this whole thought of the involuntary servitude and slavery of refusing to enforce the court rules of the Supreme Court of the state of Washington. Now, every arrogant prosecuting attorney in every county, you're getting sued. You understand?
Yes.
Because I've noticed that everybody's been saying, well, as long as he has knowledge of it, he can get arrested. The problem with this whole concept of timely opportunity,
Yes.
on page one, isn't that right?
Yes.
Is that the court rules are the definition of the due process, inclusive of the regulations and the requirements of state and federal laws. Now, I'm going to want to know the name of all the employees of every prosecuting attorney's office
Yes.
that say, well, it is legal.
Yes.
See, on June 1st of 2015, you reissued a temporary protection order.
Yes, you did.
Without any attempt of service to myself.
Yes.
And then when you reissued it, 48 days later, you issued a permanent protection order for 10 years. 10 years. Now, the two attempts of service on, let's see here, June 22nd of 2015 and July 23rd of 2015 was the wrongful execution of service because you can only reissue a temporary protection order for 14 days. The problem is this whole idea that we can try to serve the individual,
Yes.
then we can issue the protection order,
Right.
then we can serve them 2 weeks later in the Swin Public Library using an individual that's not a sheriff,
Yes.
so as to humiliate the respondent in front of all the library patrons, and then not inform the respondent before issuing of it that as an indigent homeless man, you had the right to legal counsel before it was issued. Now, you might not feel a compulsion to have the petitioner have to prove service.
Yes.
But for every prosecuting attorney that will have to prosecute any of these indigent respondents of any protection order, dissolution of marriage, I'm suing every one of you for realizing that due process is being violated.
Yes.
When you qualify for an attorney to represent you in a civil matter known as a protection order or dissolution of marriage that has any restraint provisions. Now, let's think about it again, Cal Gill. On June 16th of 2017, I made 13 videos
Yes.
that tore up this whole idea that my only remedy,
Yes.
if I had a problem,
Yes.
was to motion a court that violated the Supreme Court rules of the indigent
Yes.
to have legal counsel represent them in a civil matter.